All right. Good evening, everyone, and welcome. Thank you for joining tonight's SB 59 Know Your Rights webinar. Before we go any further, I'd like to turn it over to our interpreters so they can briefly explain how to access Spanish interpretation and what to expect throughout the webinar.
Hola, buenas tardes, bienvenidos a nuestra sesión de hoy, SB 59. Antes de comenzar, vamos a dar algunas pautas para iniciar la interpretación. Y hola, me llamo Marianela y estoy aquí con mi cointérprete Ellis para interpretar entre español e inglés. Hi everyone, my name is Marianela and I'll be interpreting today together with Ellis between English and Spanish. Estaremos usando la función de interpretación de Zoom y ya está activa la función de interpretación y las intérpretes comenzarán a interpretar después de este anuncio. We'll be using the Zoom interpreting function. The interpreting function is already active and the interpreters will begin interpreting after this announcement. Para escuchar la interpretación, pulse el icono del mundo si usa una computadora o interpretación de idiomas si usa una tableta o teléfono. Luego, elija su canal de idioma. To listen to the interpreting, click the globe icon if you're using a computer or language interpretation if you're using a tablet. Then choose your language channel. Ahora comenzaremos la interpretación simultánea. Now we'll start simultaneous interpreting. En este momento, favor de seleccionar su canal de idiomas. Es mejor que todas las personas seleccionen un canal de idioma, incluyendo las personas bilingües en español e inglés, por lo menos cuando hablan. Si deciden hablar sin estar en un canal de idioma, es posible que algunas personas que sí están en un canal de idioma no les escuchen. Recuerden que pueden cambiar su canal en cualquier momento. Y un recordatorio, si usa una tableta o teléfono, por favor seleccionar Done o finalizado para asegurar que entre en su canal. Recuerden de hablar despacio y tomar pausas frecuentes. Si hacemos esta señal o si ven el emoticón de la tortuguita, necesitamos que hablen más despacio para poder interpretar su mensaje de manera efectiva. Favor de leer preguntas y comentarios en el chat antes de responderlos para poderlos interpretar. Y favor de decir su nombre antes de hablar. Por favor, actualice su nombre de pantalla en el Zoom con su nombre y pronombre de género. Y por último, si tiene algún problema, por favor, no sufran en silencio. Por favor, comuníquense con Stephanie en el chat. Gracias y que disfruten la reunión. And thank you. You can put me in interpreting channels now.
Great. Thank you so much to our interpreters for being here tonight and making sure this information is accessible to as many people as possible. We will be recording tonight's webinar so that we can share the recording with everyone, as well as those who aren't able to be here tonight. My name is Craig Pulsfer, pronouns he, him, and I'm the Legislative Director at Equality California. Tonight, we'll be talking about SB 59, the Transgender Privacy Act, a new California law that protects the privacy of transgender and non-binary people who change their name and gender marker through the courts. We are proud to be co-hosting tonight's webinar along with our partners at Trans Family Support Services, Alliance for Trans Youth Rights, All Family Legal, California Rural Legal Assistance, and Secure Justice. You will be hearing from each of them shortly. So let's first take a look at the agenda and what we'll be covering tonight. We will first hear from Kathy Molig, Executive Director at Trans Family Support Services, who will provide some brief history and background on how we got here. We will then hear from three legal experts, Amira Hazenbush, Christine Gutierrez, and Brian Hofer, who will walk us through the new law and explain how folks can take advantage of these new protections now. We will then hear from Carla Lopez at California Rural Legal Assistance, who will provide some additional resources and information about where to go for free and low-cost legal help. And then finally, we will hear a brief personal reflection from Kanan Durham at Pride at the Pier, who is one of the lead witnesses as this bill was moving through the legislature. And we will have some time at the end to answer any remaining questions. A couple quick housekeeping items. This session is being recorded and we'll send the recording, slides, and resources to everyone afterward. Also, if you have questions, please use the Q&A box for questions during the webinar. We'll do our best to answer all of your questions before we close. So with that, I'd like to turn it over to Kathy Molig, Executive Director at Trans Family Support Services, to walk us through a brief history about how we got here.
Thanks so much, Craig. And I just want to take a moment to give a big shout out to all the co-sponsors on this bill. SB 59 has actually been years in the making, and we're really happy that we were able to get it finalized and get the governor to sign it. Just a brief sort of, if you're not familiar with how name and gender markers change in California, you can change your California birth certificate, your California driver's license, or state ID. You need a state court order decree in order to officially change your name as well as change your gender. You could do either, you could do both. It all would require a court order. In order to do this, you have to file a petition with your county clerk. It's the county in which you live in order to get that decree. One of the things that became very apparent many years ago was that most folks who file these court orders, these petitions, do not recognize that most petitions become public record. And so several years ago, we were having issues with many of our youth, our transgender youth, being outed years after they changed their name and gender marker. Oftentimes, when they hit middle school and their friends started Googling their name, they would see the court orders as part of public record. So in 2024, AB 223 that we co-sponsored along with many partners here, that was authored by Chris Ward, changed that and allowed for any name and gender marker change for a minor to automatically be confidential. But then that left our adults being out as all of their court records being public. And we always knew that we wanted to come back and be able to get the same protections for our adults. I will also just mark that in 2017, SB 179, the Gender Recognition Act, was the bill that was passed that allowed a streamlined process for this. So you no longer have to publish to get your name changed in a newspaper. It just allowed for accessibility a little bit greater for the general population. So the rest of the folks are going to talk about how you go about doing this, but we're really excited to be able to have this bill be passed that will allow for all new name and gender marker changes to be confidential, and also a means to go back if you had that gender marker and name change previous to this law taking effect.
Awesome. Yeah, thank you, Kathy, and really appreciate your partnership on getting this bill passed and signed into law as well. So thank you for that helpful background. And now we are going to move into a detailed overview of this new law, SB 59, and help folks understand how it works and how you can take advantage of these new protections. So I am excited to pass it over to three legal experts. Amira Hazenbush at All Family Legal, Christine Gutierrez at California Rural Legal Assistance, and Brian Hofer at Secure Justice, all experts in this space. Amira and Christine have probably helped hundreds, if not thousands, of people change their name or gender marker. So excited to have all of them with us to give this overview of SB 59. So I will pass it over to Christine to get us started.
So, what is SB 59? SB 59 signed into law on October 13th, 2025. In sum, does three things. First, it makes adult name and/or gender marker corrections filed on or after July 1st, 2026 confidential. This includes name changes to conform with gender identity. There's change number two. SB 59 creates a pathway to make those filed before July 1st, 2026 confidential. And 3, it creates a penalty if someone shares your court record without your consent. So change number 1, adult legal name and gender marker corrections filed after July 1st, 2026 will be confidential. This is the most straightforward part. Basically, if you file after July 1st, your record is confidential at the time of filing. Now, if you want to double check it's confidential, you can go to the website of the court you filed, go to the case search, and search using your dead name. You can also search using your case number. If your record shows up, you can let the court know, and they should fix it, and then you can check online again.
So I'll take over in talking about option number 2, or the second change. And my name is Amira Hazenbush. What is happening is for people who already have their court records either filed at this point and not completed, or filed and completed and not confidential, we still would like to be able to make those records confidential, but it will not happen automatically like it will for people starting in July of next year. So for anyone who files between now and July, or who filed before now, what we need to do is we have to file what's called an ex parte request, which is sort of like an emergency request that you can file without having to go through a more formal process to request that your records be made confidential. Now, there's a few important things to flag for this. The first is that if you're filing on your own and you didn't previously have a fee waiver, there should not be a fee to file this case. It should be able to be filed without a fee from the court. However, this is something that is newly being implemented, and I can tell you at the very least in Los Angeles County right now, they are charging the fee, and we're taking some time to get that fixed. So it's kind of up to you if you want to wait until those fees go away, or if you're willing to just pay the fee. In most counties, the fee will probably be somewhere in the range of $75 if you don't have a fee waiver. The other thing that's important to know is that you need certain forms to be able to file that ex parte request. Now, there's an organization called the Judicial Council who helps put together official court forms, and eventually they will put forth a form that you will be able to use to fill out to make this request. But until then, we have collaboratively put together some forms for you to use so that you can make this request. And they're available at the link that is showing on your screen right now at crla.org. And that you'll have to tailor it. You'll have to put in your name and your information and your case number so that you can file that with the court. These forms are for reference. They are not legal advice, but they should be usable and accessible so that you can make that request yourself. Can we go to the next slide, please? So these are some samples of the forms. You'll see there are 2 primary forms that you'll be filling out. One is your request, and it includes a declaration that just requests that the record be made confidential. Can you go to the next slide, please? And that states that you are the person making that request, and you're requesting that your records be made confidential in their entirety. And we can go to the next slide, please. And then you'll have a proposed order. The orders will look slightly different for minors under the age of 18 and for adults, but these proposed orders have the exact language from the statute as to who should be able to have access to the case. So even though you're requesting that your records be made confidential, the new law still allows you to access your case. If you have a lawyer, your lawyer should be able to access your case, and you can give written consent for other people. For example, if you need to go get certified copies of your case and you're at work and you can't go in person, you can write a letter and allow someone else to access your records. But otherwise, they should not be available online. They should not be generally available to the public. They should otherwise be confidential. Can we go to the next slide, please? So each county is different in how you're going to make this request. You're going to start by either downloading the forms from that website or creating your own forms where you request that it be made confidential. Again, you should be able to file this without a fee. If you file electronically, that may be more challenging because they have to update their electronic systems in order to be able to allow you to make that request without a fee. You can also go in person to the clerk's office if you are not a lawyer. If you are self-represented, you are generally allowed to go in person and make that filing, and that may be an easier way for you to file and make sure that the fee is not charged. Again, because this is new, not every clerk is going to know what's going on. I just had a hearing on one of these requests this morning and had to teach the judge the law this morning in real time. So this is something, it's only a month and a half old at this point. People are still learning, and so they're not sure what's going on when you make this request. But you should go ahead and file. You may need to go into the court the next morning or the following morning to ask the court to actually grant your request. So an ex parte, if you file before 10 a.m., is usually held at 8:30 a.m. the following day. If you file after 10 a.m., it's usually held at 8:30 a.m. 2 days later. Now, because this is a statute that says it has to be granted, even if you don't show up, the judge should grant it. But again, because this is such a new law and the judges don't know about this law yet, I recommend that you ask when the hearing is going to be and you show up to explain to the judge the new law. Once you get that request granted, again, you can go on the website, as Christine explained, search your case number, search your dead name, make sure you no longer see it. If it's been granted and you're still seeing it on the court's website, you may need to call the clerks and explain to them that the court has granted your request to make things confidential and ask them to take it off the website. Again, if you can get a copy of that court order that says that it's made confidential, that should help for the clerks to be able to review that and make it confidential. Can we go to the next slide, please? If your request is denied, either you go to your hearing and the judge denies it, or you don't go to your hearing and you find out later that it was denied, you should ask the clerk why it was denied. What is most likely to happen is for it to get rejected in the filing process itself before it makes its way to the judge, especially if you're doing electronic filing. Again, because this is new, there may need to be some back and forth. You can always reach out later. We'll talk about the organizations who are available, but if you're having any issues with getting it filed in the first place, or if you've gotten all the way to the judge and the judge has said no, then you should reach out to, one of these websites, find a legal organization that can help you to get it refiled and processed and accepted. All right, I'm going to hand this over to Brian.
Great. Thank you, Amira. And I just want to say really thank you to all the co-sponsors and Senator Weiner, who sponsored this bill, and the attorneys practicing in this area that have advised us throughout this process. What happens if we aren't being protected by this new law? SB 59 has two private rights of action, although I would think probably 9 out of 10, maybe 10 out of 10 times an injured party is going to use both because they serve different purposes, which I'll describe, and they will both likely arise in each scenario. There is a safe harbor provision because this is a new bill. The court needs time to get up to speed and train the staff and fill out the forms, as you've heard. So beginning April 13 next year is when the safe harbor provision expires. And if you've been doxxed, your records have been accessed without your permission, that's when you can start enforcing your rights. So the first right of action is for when you need a party, whether it's the court itself, Google, an individual, to perform some action that they have failed to do, like make the records confidential, or to stop doing some unlawful action that they are presently doing, like posting your documents without your permission. Let's say that situation happens. Some classmate, some coworker puts your records that they somehow illegally got up onto a website. You would go to court and ask for an order compelling or mandating that website to take down the documents. And if you prove your allegations as the prevailing party, you would get reimbursed for any attorney's fees or court costs spent in enforcing your rights. And this first right of action can be used against anyone, the court system itself, if they made a mistake, for private businesses, or for individual natural persons. The second private right of action is to compensate you for harm from having your records exposed without your consent. In that same scenario, let's say a classmate or coworker got your court petition and started sharing it around on social media. You would use the second right of action to hold them accountable for the harm that they caused you. And if you proved your allegations that showed that they harmed you, you would recover attorney's fees and court costs like the first private right of action. You would also be entitled to some amount of monetary damages. In privacy scenarios like this, and for those of you that don't know Secure Justice, we're a privacy-minded organization. We work on both kind of consumer and government sides of the coin. It's really hard to quantify a dollar amount for the harm you suffered, the invasion of privacy. And so SB 59 provides either actual damages suffered or a liquidated damages penalty in the amount of $5,000, whichever is greater. Depending on the fact pattern, if the offending party's behavior was really egregious, malicious, they spent a lot of effort really just trying to harm you, you might be awarded to what is called punitive damages, and that could be pretty significant. For a simple takedown order, these are not expensive legal actions. I've filed one that was like $2,000, and that was including the filing fee. A damages claim might be more complicated and might take a little more time. For a simple takedown order, those are given preference on the court's calendar. Writs move very fast, which is great when your privacy is at risk. And with an attorney's fees provision, I can't speak for anybody in the industry, but you might be able to find someone willing to take the case on a contingency basis where you don't pay any money up front, and then the attorney recovers on the back end. That is going to depend on the strength of your case. And if you need help finding legal professionals, you can search on lawhelpcalifornia.org. I believe we have a link we can share. The Legal Aid Association of California. I know organizations like Equality California and many others will also be posting similar resources.
To review, the three changes from SB 59 are the following. Number one, if you file a name and gender marker correction after July 1st, 2026, it's required by law for it to be automatically confidential. Change number two is if you file a name and gender marker correction before July 1st, 2026, it won't be automatically confidential, but you can request it to be confidential, and that request must be granted. And finally, starting April 13, 2026, you can sue if someone shares the court record of your name and gender marker correction without your consent.
Great.
Great. Yeah, thank you so much to all of you. Very helpful overview, and I know we have a lot of questions in the Q&A, and we are going to have time to get to all of those questions. So just have two more folks on the agenda, and then we will get to the Q&A. So I am next going to pass it over to Carla Lopez at California Rural Legal Assistance to talk about some of the resources that are available to help.
Thanks, Craig. So yeah, I'll be talking and walking through the main resources and legal assistance available to support trans and gender diverse people in California file confidentiality requests under SB 59. There are three main resources we want to highlight, and the most important resource is the SB 59 self-help toolkit that's available on the CRLA website. This toolkit was designed to help people file the confidentiality request who can't or don't have access to legal support. Inside the toolkit, you'll find fill in the blank sample forms, instructions for submitting an ex parte request, aka the confidentiality request on your own, these webinar slides, links to resources and organizations we're listing here, and FAQ sheets for community members, and another FAQ sheet that you can bring to the court. Um, the community-facing FAQ sheet, which is in Spanish and English, outlines what protections SB 59 provides, what records become confidential, how you can make them confidential now, and what your rights are if someone shares your records without your permission. Again, that toolkit is free and meant to be customized to your situation. Um, so that can be found on the CRLA website. The next resource listed is the California Court Self-Help Guide. This walks you through the name and gender marker correction process for adults and minors in California. And then lastly, we also include the court directory link so that you can quickly find your local Superior Court and check how to file your request, whether that's in person, online, or by mail. Next slide. Okay, and these are legal options across California rather than bulkily listing every organization in their county. I just want to highlight the bigger picture, which is that there are legal aid organizations, LGBTQ plus community centers, and law school clinics across California that do help people navigate name and gender marker corrections, filing SB 59 confidentiality requests, and addressing issues with the court. So if you need legal assistance or run into problems, you can contact these orgs or head to legal.eqca.org, which is a great website that lists local support statewide. So key takeaway, SB 59 provides strong privacy protections, and you can request confidentiality now. The SB 59 toolkit has what you need to start that process on your own, and there are legal aid partners across the state who can support you if you need help. Thank you.
Awesome. Thank you, Carla. And then our last speaker tonight before we go to Q&A, excited to have someone with us tonight who was one of the key folks who helped get this bill signed into law. Kanan Durham from Pride at the Pier was one of the lead witnesses as the bill was moving through the legislature. So excited to have Kanan here to talk about why this bill is so important.
Hi, guys. Yes, thank you, Craig. As you mentioned, I was one of the lead witnesses in front of the Assembly Judiciary Committee for this bill. And the entire reason why is because I unfortunately have been the victim of transphobic doxing, which, long story short, it sucks. But in a little bit more detail, what happened to me? I'm an activist here in Huntington Beach in Orange County. I'm a very loud and proud trans person, and as a result of that, there were some local self-identified surf Nazis who decided to dig up my information using the available information within the court systems to get a lot of information, but including my dead name. And then they went and shared that information in circles with Proud Boys and active club members. Just just a long slew of people who want to make trans folks' lives miserable. And I had folks sending things to my house. I had, they did a, where you deliver pizzas with cash on delivery with my dead name. They were spreading my dead name and my face all over, Telegram and whatnot, which was terrifying. Getting my name and gender marker changed was like that day where I got that legal change done was one of the best days of my life, and it still is. But as I said to the Assembly Judiciary Committee, that experience has now been tainted because now I have all these folks out here who have that information and want to use it against me, in an attempt to humiliate and an attempt to terrify. Um, and I am not the only person in this state that that has happened to. So I was really, really honored to be able to share my story with the Assembly Judiciary Committee and to be a part of the history behind this bill. I genuinely think it's one of the most important things I've ever done in my life, and I'm really looking forward to all the folks in this state who are going to be able to protect their information and live with the dignity that we deserve. Thank you.
Thank you, Kanan. Thank you for sharing your story. Thank you for helping get this bill across the finish line, for being here tonight. Before we move into Q&A, I did just want to, take a moment to thank everyone who helped get this bill signed into law, everyone who made calls, sent letters, showed up in Sacramento to testify. All of those actions were incredibly, incredibly important. And Brian mentioned, the author of this bill, Senator Wiener, who has been an incredible champion on this issue, and also just want to give shout out to his staff, Ricardo Gonzalez, who was really instrumental in getting this bill through the legislature as well. So with that, we're going to move into Q&A, and going to open it up to any of you to answer these questions as they come up. A lot of questions really just wanting to really clarify specifically some of the issues as it relates to minors. Kathy talked about the protections for minors that went into effect in 2024, but folks have a lot of questions. What about minors who changed their name or gender marker before that time? So, Amira, if you could help clarify, what do minors specifically need to do to make their records confidential?
Sure.
Can I summarize a couple of the questions together for you,
Yeah,
Amira, that
please.
might be helpful? So we're okay.
By
So
all
first of
means.
all, clarifying again what Craig just said, if the name change was done prior to January of 2024, it is not confidential. So
Correct.
you definitely have to do an ex parte to get that confidential for anyone that was prior to January 2024. I also tell people check. Google your kid's name to make sure, because certainly the courts make mistakes, and in particular in the first part of 2024 when it was a new process. So the other questions, Amira, are can my child still get this confidential if it was prior to 2024? Another question is, if they are now an adult, do they still file the ex parte? Do the parents have to because the petition was on behalf of? And what that process looks like. And there was one third one, but start with those.
Okay. Yes. So before 2024, it is not confidential. You have to go through the same process as everybody else. After 2024, it is hopefully confidential. I would say, in addition to Googling it, I would go specifically into the court's website and search for the case number and the name of the petitioner. For minors, the petitioner name is going to be one or both of the parent names. So search parent name, search dead name, search case number, search all of those to make sure that it's taken down before you decide whether or not you need to file the request. If you need to file the request on behalf of a child, it is going to be the same process, except that you, as the petitioners, in the same way when you filed the initial petition were the parents, it will be the parents petitioning. If the person has turned 18, I would argue that any one of you, whether it's the parents or the child, any of you could file that petition. If everyone's still on good terms with each other and working together, probably the easiest thing is to just have the parents and the adult child all sign it just to be safe. But I think that any single one of you would be fine for that purpose. The other thing I wanted to flag is that until this law was passed in October, name changes to conform with gender identity that did not have simultaneous gender marker changes were not confidential. And so if you as an adult or your child changed the name to conform with gender identity but did not also request a gender marker change in that same proceeding, then it was not confidential. And if you want that to be made confidential, you now have to make that request. Did I answer both questions there? Okay, great.
Okay, so we're going to continue moving through our question list. We have one here. Do people who change their name or gender marker prior to July 1st, 2026, do they have to wait until July 1st, 2026 to make those records confidential? We'll just quickly answer that one. You do not need to wait until July 1st, 2026. You can start taking advantage of these protections now using the process that Amira outlined. And another question here, which I think we've discussed a little bit already. How do I know if these records are confidential? If I search for my child's name in the court system and no case comes up, does that mean it's already confidential?
Yes. If you're not seeing it in the court system, when you search your child's name, your name, and the case number, then it's not public. I would do a search for all of those in the court system and do a Google search, because if it was temporarily up and then taken down, it's possible that it may have gotten scraped by a third-party publisher and posted more publicly. So I would search in all of those places. If you don't see it, you should be okay.
Okay, great. This next one is a good question, specifically related to the ex parte request hearing details. Will those also be kept confidential by the court?
That's a good question. Most courts at this point have low enough funding that they don't have court reporters on hand. And so it is most likely that your request in and of itself will not have someone typing a transcript during the hearing. However, the hearing is public. There are other people who are at the hearing. Um, Most judges, if you go in person and you say to the clerk, this is about confidentiality, I would like to be heard separately or in chambers, would mean talking to the judge in their private, office. They may accommodate that request, but if they do, they will most likely make you wait until the end of the calendar, meaning you will be the last person called. So, for example, this morning I was held until the end of the calendar. My hearing was scheduled for 8:30 a.m. I didn't get called until after 11 a.m. So if you're going to request that you have some sort of special accommodation for it to be confidential in the hearing itself, you will most likely have to wait longer. That being said, the hearing itself is usually not exposing a whole lot. You can kind of speak in generalities and say, this is a case that under Health and Safety Code 103437, it is now required to be made confidential. And you don't have to necessarily say what that is. If you slowly give that case the code number, again, it's Health and Safety Code 103437. If you give that to the judge will look it up and we'll start reading. That's exactly what happened this morning, was the judge was like, wait, okay, hang on, let me read what this is about. And so there are ways to make the request without being very vocal in exactly what it means to be making that request, in case there are other people in the courtroom that you're worried about hearing it.
Great. And I did, for folks who are, furiously taking notes of everything that's being shared, I did just want to emphasize, the link that we shared in the chat that takes you to the California Rural Legal Assistance website. So all of the forms that Amira discussed are on that website. We also have a frequently asked questions document that you can use that has answers to all of the information that we're presenting tonight. And then there is also an FAQ for the courts that includes those specific code sections. And so, there is a document that you can bring with you to the court that will have that specific code section that Amira just mentioned. And so we have prepared all these resources again that you can access that on the website, not only for yourself, but also to bring to the courthouse so that you can help educate the court staff if you need to.
Great. Thanks, Craig. I'll take a couple more of the questions in the Q&A. Brian, maybe you can answer this one it's dualed. What constitutes harm? And also, can you explain the difference between court documents being confidential and being sealed?
Sure. And great question regarding harm. I glossed over that. Uh, Thankfully, from experience, we realized that this is one of the more difficult things to do in a privacy scenario. And so SB 59 includes language that says any violation of this law constitutes an injury, which means you just have to show that there was a violation somewhere. If you have real damages, like you really were harmed, you were outed, there's, you know, all sorts of terrible things going. You have to prove those things, but of course, that in and of itself is going to be an injury. But if you can just show that your documents were posted online without your consent, that itself is the injury, is the harm. You should at least get the $5,000 penalty. And that's what that's used for, where it's harder to sort of put a concrete number on a damages claim, which usually requires an expert witness, and it's just a lot more complicated that way. Um, Confidential versus sealed. Um, One of the reasons Secure Justice got involved was a case of first impression last year in re-MT, and where the petitioner was able to show that they had been harmed by being doxxed, and it was of a significant level that they met the existing criteria under the rules of court to have their records sealed. In practical terms, the mechanics of asking are similar, like how you go to court and you file a petition. You do have to meet a higher criteria, as I just stated, in order to do that. And it makes it more difficult to unwind. We don't want to give the false impression that under no circumstances can confidential records ever be involved. And I know, I think there was a related question about the Trump administration, and, people are rightfully concerned um, by his approach towards trans individuals. But the sealing of these records creates a much higher burden to clear to ever get access to them. But you do have to meet different criteria than just a simple confidential records request.
I would also just flag one other thing with the sealed records is that it is not uncommon that when you get the record sealed, it is sealed from everyone, including you. And so if you need certified copies of your records and it gets sealed, I have cases now where it was accidentally sealed instead of made confidential, and even the clerks can't get into the record to get certified copies for my client. So if you are going to ask for it to be sealed, I recommend that you get as many certified copies of your records as you need before that seal request, because otherwise you might not be able to get it later, or you might have to go through a lot of hoops to get access later, even as the client.
Excellent. Thank you so much, both of you. One other one that I think is really important to address, if the court order was scraped by a third-party publisher like Trellis, how do you address that if you're doing the ex parte?
So Trellis, I have found that if you explain to them that the law requires, so at least with the children, because it was already required for minors, when I was just sending them a note, and they have like an online system where you can request a takedown. And if you say this is now required to be made confidential, if requested, they usually will take it down. I have found that those come down usually within about 24 hours of sending that request. It's my hope that eventually they will learn the law and take them all down proactively, but you may still need to be making the requests individually.
Okay, a couple more questions. So I see one question. Do the self-help materials on the California Rural Legal Assistance website include templates for parents petitioning on behalf of a minor? Yes, those materials will also help parents who are working with minors as well. Two questions, just the process for the ex parte request. So one, will I first need to call my courthouse to schedule an ex parte hearing? And then the second one, is it possible to make an ex parte request without going to the courthouse in person at all? Specifically, someone who has lived in Massachusetts for the past few years and does not go back to California often.
Yes, so you can file electronically. You don't have to file in person. If you file electronically, though, you most likely will be charged the filing fee, at least until they get their systems corrected so that you won't be charged for that anymore. Generally speaking, ex partes are scheduled automatically the following day after you file, if you file before 10 a.m. So if you file before 10 a.m., your hearing will be at 8:30 a.m. the following day. If you file after 10 a.m., your hearing will be scheduled 8:30 a.m. 2 days later. So you don't have to call ahead to make that schedule. An ex parte basically means it's an emergency petition. And so all ex partes get scheduled in this way, where you file before 10 a.m., it gets scheduled at 8:30 the next morning, or after 10 a.m., 8:30 2 days later. So just prepare for whenever it gets accepted. If you're filing electronically, sometimes it might get rejected. And then when it gets rejected, suddenly it pushes you till after 10 a.m. once you refile it. And so then you're pushed out a day. So just keep that in mind when I would say when you're filing, plan to have 8:30 a.m. the next day and the day after that both available just in case your filings get pushed till after 10 a.m.
A follow-up to filing for ex parte question. Do you list your current legal name or the petitioner's name? Do you need to file it exactly as the petitioner of the original court order?
I recommend that in the caption, which is the top half of the page, which you'll see on the sample documents, you have to have it exactly like it looked on the original petition. But if you want to sign with your current legal name, I think that's totally appropriate and reasonable. If you want to say I, and you use your current name as your declaration, I think all of that makes sense. That is your legal name, but the case name doesn't change. And the case name is the name of the original petitioner, which is either your dead name or the parents' names who filed on your behalf. And just one other thing for the person who asked about being out of state, most courts now have abilities to do remote hearings. So you can make an appearance either through their online, they might have a Zoom hearing system. LA County has something called LA Court Connect. They have a whole system. Some counties that are more rural might not have video systems yet, but most will still have access to what's called court call, where you basically call in and you can be heard by a phone call. Most of the online Zoom systems are free. Court call still charges for those phone calls. So it depends on the county where you're filing.
Amira, one quick question. Just can you tell folks where to go to search their court records and if it costs any money?
So it's by the county that you filed in. You're going to go to that county court's website, and there should be something in the website like online services. If you search whatever county it is, so let's say it's San Diego County, you could put San Diego County Superior Court online case access. If you just put that into Google, it should pop up with the link, and every court is different. Some have very accessible, everybody can just put a case number in it, it'll just pop up. Some people might have to pay a few dollars to do the search. Some you'll have to create like an online login in order to be able to get in and do the search. I think I saw somebody in the chat say that their county, everything was blocked. There was no access to search at all. If that feels safe enough for you, that's fine. If you want to be extra cautious, you could go down to the courthouse because there are some counties where they don't have external online access. But if you go to the terminals in the courthouse building, they'll have computers where you can search the records inside of the courthouse building, but not outside the courthouse building. So every county is a little bit different. You can always go to your county self-help desk and ask them how to access a case. They should be able to answer that very easily for you.
I see multiple questions in here about birth certificate corrections being confidential. Is there a way to make them confidential? Some people who had name changes outside of the state, but the birth certificate was in the state. Can you address birth certificates, one of our legal fellows?
I can answer this one, and correct me if I'm wrong, anyone, but in general, here in California, birth certificates are confidential, meaning someone can't access your birth certificate. Um, and in regards to out of state birth certificates, it's going to depend on that state. So let's say that you got your name and gender marker correction here in California, and you have a California court decree. the state may accept that as enough documentation to change their birth certificate, but it is the state's prerogative on what they require, and it depends on each state, and so I can't speak on what other states require when updating your birth certificate.
Yeah, I'm just going to add a quick clarification on that. So in California, the birth certificate, once you've amended it if you're changing your gender marker on your birth certificate, your old birth certificate is confidential. So no one can access the original one. But actually anyone can access anyone's current birth certificate in California. If you ask for an informational copy, it will say on it informational copy, but I could literally look up a celebrity's birth certificate who was born in California right now if I wanted to. So, but the change of the gender marker will make the original one sealed and confidential, so only the new birth certificate will be accessible. If you change a name without changing a gender marker, you will end up with a two-page amended birth certificate. And so the first page will be the original birth certificate, and the second page will show that amendment. So if sometimes people want to change their name at one point and their gender marker at another point, I generally recommend that you don't change your birth certificate until you have everything ready to go at once, because you only get one shot to have the original birth certificate sealed. So I've had clients who've done a name change to sort of a gender neutral name and a gender marker change, and then they've then changed their name again, and that gender neutral name will then be stuck on the first page, and the second name change will be on the second page. So, you kind of only get one time to make that fully confidential.
Thank you. So part of three different questions here. One is there advantage to wait until after Judicial Council streamlines this process, which we know is going to be July? And then a yes to that, because the other two are commenting about that they've already tried to do this and are still charged the fee. Is there any way to get their fees reimbursed? Or if you do file online, is there any way to later be reimbursed for that filing fee?
Christine, you want to take it?
Oh no, I was just gonna say I can't speak on reimbursement. I don't know if you know more about that, Amira.
Yeah. So the reimbursements are a gigantic pain. You can get reimbursed. Again, each county is going to be different. LA County actually has a form for requesting a reimbursement. I have found that in my experience, like for example, when the court accidentally charged my client two filing fees, and people know that the initial filing fee for a name change is $435. So getting charged that twice is very expensive. It took many, many hours because you file the request, the clerks have to sign off on it, and then we had a check that was like mailed to Arizona and then somewhere else, and then it finally got back to us after like 6 weeks of follow-up phone calls. So, it depends on, people's individual needs in terms of the time cost trade-off of trying to get $75 back. Also, for e-filing, I don't believe that the e-filing service fees will be waived. So if this isn't clear to folks, when you e-file, there are two fees. There are the court's fees, and then there's an e-filing service provider who's the facilitator of the e-filer. So the way that I would think of it is, if you were mail filing, there would be the fee to the court and the cost of the postage. This is kind of the electronic version of that. So the cost of the postage doesn't necessarily go away. So that e-filing service fee, which is usually between $10 and $15, that will probably still be there. But the court's fee, which is usually about $60, is the part that should be removed. Now, in terms of whether it makes more sense to wait until July 1st, most likely at that point, the courts will have figured this out. And so it will probably be easier then, but if it feels more urgent for you to get it done sooner, then you can certainly do that.
Awesome. Thanks so much. Just the last kind of round of questions here. There's multiples having to do with federal identification. So how this affects passports. If a change of name conflicts with the name on a passport, will the federal government honor that new name and issue a new passport? There's also a question in here about the draft card. I'm going to go ahead and answer the draft card because I recently have walked through this with one of our families. It is recommended at this point that draft cards just remain as they are, because there is no draft, and you would be highlighting your child's gender marker changes to the federal government, which is not a recommendation right now. I'll also answer passport, and if anybody has something to add, they can. Passports, they are honoring court orders with people's name changes, but they are currently not changing any gender markers. So the advice we are giving our families is if you have a need for a passport right now, to go ahead and get it changed. If you do not have a need for a passport, in particular for your minor child, there's really no reason to do the passports until we can go back to the way the rules were for decades prior to where we are now. There is also still litigation happening against the current rules. But if I said anything incorrectly or any of you have more information, please unmute. Amira, thank you.
Yeah, I think that's accurate. The one thing I would add is that if you have previously changed your gender marker on your passport and you need to update your passport, it is very likely that the federal government will revert your gender marker back to your sex assigned at birth. And that may result in you having the right name and the wrong gender marker on your passport if you need to travel, and that's just what you have to deal with, and your other IDs have the right name and the right gender marker. You may want to consider bringing your court order, if you have it, while you travel, so that if there's any confusion and for whatever reason you have to pull out two IDs with mismatching gender markers, you can show that there was a transition at some point and that there's no fraud going on and that you just, you couldn't get your records to be updated in the way that they needed to be.
I'll just add real quick, Craig, and then I'm going to give it back to you. There were some questions we were not able to get to. The folks that are listed on the resources that you have been given a link to are passionate. The folks on this call are passionate about serving this community, about bringing you the most up-to-date information. So please don't hesitate to reach out. Sorry if I stepped on your toes there.
No, absolutely. Yeah, I just want to, really thank all of our panelists tonight. This was a lot of information to cover, so thank you all for sharing your knowledge with all of us. And echoing Kathy, there are a number, many folks across the state who are ready and willing to provide support. So we will be sending out a recording of this webinar. We will send out a copy of the slides, links to where you can find additional support, and copies of those frequently asked questions documents that we mentioned. And a reminder, all of these documents are available on the website for California Rural Legal Assistance. So there is more help. We are happy to, continue dialoguing and helping, answer your questions. And like Kathy said, the folks on these calls are ready and willing to help. So really just want to thank all of you for making time to be with us tonight, and we will follow up very soon. So thank you all for joining us.